Okay, good morning. We'll start now. And we were supposed to start from order number 11. Okay, we have done till order number 10. Till order number 10, it was like examination of parties by the court. So when the court comes to know through the pleadings whether the facts have been admitted or denied, then means looking at the plaint and looking into the written statement, then if it feels that it is admission, then well and good. If it is denial, whatever it is, court will record its findings, right? Then after recording these admissions and denials, court directs the parties ki bhai you can opt for outside court settlement also. So we all know that 89(1) talks about these settlement methods like arbitration, mediation, conciliation, lok adalat वगैरह. Right? These are known as ADRs. So if they say, okay, well and good, we'll go to the forum or authority for settlement. The parties go and appear before that. If a settlement strikes, well and good. But if it doesn't, they can come back to the court. And court will follow the normal course. After that, examination होता है, oral examination of the party or a companion of the party जो भी होता है, right? And whatever examination has been done, it has been written. If the pleader is there, party is not there, and if the pleader is obviously unable to answer, then they shall fix a day, right? That you can come with the person, the party, and then answer the things, right? This is it about till order number 10. Order number 10 तक आपको सब पता होना चाहिए अच्छे से. Coming to order number 11, it talks about discovery and inspection. With this, you have to read section number 30. Section number 30 also empowers the court to make an order for discovery. We have read. You all can turn your page and see section number 30. Of whenever you study and wherever I have made you mark, right, read with this section, this order. अगर आप अपने पेजेस घुमा के वो देख लोगे, ऑटोमेटिकली आपको चीज़ें याद भी हो जाती है, राइट? So with this order number 11, discovery and inspection, you read section number 30, power to order discovery and the like, right? So you will see this section on the application of the party or on its own motion. Court with this different kind of conditions and limitations, court may at any time either order this, right? It can make an order for sending of interrogatories and answering them, admission of facts, discovery, inspection, production of evidence, impounding of documents, material objects, वगैरह वगैरह, right? So firstly, discovery by interrogatories. Rule number 1, interrogatories means questions. Okay, so if in any suit the plaintiff or defendant by the leave of the court may deliver interrogatories in writing for examination of opposite party or any one of such parties, and such interrogatories when delivered shall have a note at the foot thereof stating that which of such interrogatories are required to be answered. Proviso that no person shall deliver more than one set of interrogatories to the same party without an order for that purpose. Proviso also that interrogatories which do not relate to any matters in question in the suit shall be deemed as an irrelevant one, and notwithstanding that they might be admissible on the oral cross examination of the witness. So interrogatories का पूरा एक सेट कोर्ट को देती है पार्टी कि भाई दूसरी पार्टी को आप ये क्वेश्चंस पूछ लेना, और obviously they have to be relevant, they cannot be irrelevant. Okay, particular interrogatories to be submitted on application for leave to deliver interrogatories. The particular interrogatories proposed to be delivered shall be submitted to the court, and the court shall decide within 7 days from the day of filing of the said application. In deciding upon such application, court shall take into account any offer which may be made by the party sought to be interrogated to deliver particulars or to make admissions or to produce document relating to the matter in question or any of them, and leave shall be given as to such only of the interrogatories submitted as the court shall consider necessary, either for disposing fairly of the suit or for saving of the cost, right? So this application is been decided within 7 days. Costs of interrogatories जो भी होता है, right? in adjusting the cost of such inquiry shall at the instance of any party be made into the propriety of exhibiting such interrogatories, and if it is the opinion of the taxing officer of the court, either with or without an application, interrogatories have been exhibited unreasonably, vexatious, improperly length, right? So the party which is at fault will pay them. Basically, I have never seen any kind of question coming from this order, but इसमें क्या होता है कि you are basically getting to know more about the suit, right? So you just know what it is about, right? Interrogatories, discovery happens with getting the documents, right? See, application for discovery of documents, right? Discovery of documents on oaths, ये सब चीजें आपको एक बार थोड़ी पता होनी चाहिए कि what are they trying to say. Now see this rule number 6, objection to interrogatories by answer. Any objection to answering any interrogatory on the ground that it is scandalous, irrelevant, it's not bona fide, right? Or that the matter inquiring into are not sufficiently material at that stage, or on the ground of any kind of privilege may be taken in affidavit in answer. Means उनको लगता है कि इसमें कुछ नहीं है. Setting aside striking out interrogatories वाला भी एक concept है. So for this particular thing, you can just take into consideration what are they trying to say. It is very much necessary to get those documents because they will be used for the purpose of for disposal of the suit. So the parties can make an application, right? Okay, we want these particular documents, we want these questions to be answered. So that is what applies in this. Acha, in this rule number 23, order shall apply to minor plaintiffs and defendant and to the next friend and guardian for the suit of persons under disability. So if a question comes, does order number 11, which is with respect to discovery and inspection, does it apply to minors? Yes, it does apply to minors. They have particularly said under rule number 23. अभी इसमें इंस्पेक्शन होता है. आप इतना लिख दीजिए, द प्राइमरी ऑब्जेक्ट of rule number 15 to 19, okay, is to place the opposite party in the same position as if the documents had been fully set out in the pleading or the affidavit. Means आप समझ रहे हो ना, if there is a suit between two parties, right? Obviously the opposite party also needs to be aware of what the documents the other person is going to be filing for claiming, right? So he can also prepare his defense attack, right? Basically not to put the other party at surprise. So this provision of inspection allows that, right? कि you can inspect the documents वगैरह. That's it. Order number 11, just keep this much in mind. Nothing more comes from this. Just know one thing, that yes, it does apply to minors. Now, admission. We all know in Indian Evidence Act, section number 58, it says that facts admitted need not be proved. Simply it is over here that. Okay. Object of admission is to dispense with the proof. Also, it aims to save the cost of such proof, and it also cheapens and shortens the litigation, right? We are aware of these concepts behind admission. If a fact is being admitted, right, obviously costs are diminished, the litigation is shortened, it even saves the court's time. So that is what this order is talking about, admission. We all know whatever is being admitted, it is the best, it is the strongest form of evidence, right? So know one thing, that you should know firstly under which order it falls. It falls under order number 12, right? And इसमें दो रूल्स आप याद रख सकते हो. एक होता है रूल नंबर 2 और एक है रूल नंबर 4. रूल नंबर 2, first we'll see rule number 1. Notice of admission of a case. Any party to a suit may give notice by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case of another party. है ना? मीन्स मैं पूरा का पूरा आपका केस ही एडमिट करता हूँ भाई. ओके फाइन, आई एम एट फॉल्ट, राइट? दैट इज व्हाट दिस rule number 1 says. Notice to admit documents. Either party may call upon the other party to admit within 7 days from date of service of notice any document saving all just exceptions, right? जैसे कि all just exceptions are like, for example, a disability, right? Or the person is a minor, some kind of these leaving barring these exceptions. And in the case of refusal or to neglect to admit after such notice, the cost of proving any such document shall be paid by the party who is so neglecting it or who is so refusing it, right? Whatever the result of the suit may be, unless the court otherwise directs. And no cost of proving any document shall be allowed unless such notice is given, except where the omission to give notice is, in the opinion of the court, a saving of expense, right? Firstly, इसमें आप एक चीज याद रखना, there are we know that admission is a substantive proof, but obviously it is not conclusive, right? So through admission, like I said in the starting, you are shortening the litigation process and saving the cost over there. So rule 1 talks about that the party admits the entire case. Rule number 2 talks about the one party sends a notice to the other party that you admit these documents. Okay, and after after the notice 7 days is being given, and if the party admits, well and good, but if the party does not admit, then that other party will have to pay the cost for why he is not admitting, right? Now go to rule number 4. It talks about notice to admit facts. Any party may by notice and writing at any time not later than 9 days. See, remember these days वगैरह for prelims. वहाँ पे 7 days था, यहाँ पे 9 days है, right? Before the day is fixed for hearing, call on the other party to admit for the purpose of the suit only any specific fact or facts mentioned in such notice, and in case of refusal or neglect to admit the same within 6 days after uh, after service of such notice or within such further time as may be allowed by the court, the cost of proving such fact or fact shall be paid by the party who is so neglecting or refusing, whatever the result of the suit may be, unless the court otherwise directs. Proviso that any admission made in pursuance of such notice is deemed to be made only for the purpose of the particular suit and not an admission to be used against the party on any other occasion or in favor. So it is only for that particular suit, right? Judgment on admission, remember that where admission of facts have been made either in the pleading or otherwise. So in either in the pleading लिखा है तो वहां पे लिख दीजिए order number 7 rule 8, और otherwise लिखा है तो आप वहां पे लिख सकते हैं order number 10, order number 11, order number 12 and order number 23, right? Whether orally or in writing, the court may at any stage of the suit, either on the application of any party or of its own motion and without waiting for the determination of any other question between the parties, make such order or give such judgment as it may fit having regard to such admission, right? Whenever a judgment is pronounced, obviously a decree is drawn up on that. Affidavit of signature, so an affidavit of the pleader or his clerk of the due signature of any admission made in pursuance of the notice to admit document of fact shall be a sufficient evidence of such admission if evidence is required, right? So notice to produce documents shall be in form number 12 appendix 6 with such variations as circumstances may require. Okay, and affidavit of the pleader or his clerk अगर वो necessary हो तो वो आप दोगे as a proof and evidence. Cost, if a notice to admit or produce specifies documents which are not necessary, the cost which are occasioned thereby shall be borne by the party who is giving such notice, right? अभी ये ऑर्डर नंबर 13, सी इसमें कुछ कुछ जैसे ऑर्डर्स है, सीपीसी में क्या है ना, वो लोग डायरेक्टली क्वेश्चंस पूछ लेते हैं जस्ट बाय राइटिंग दैट दिस फॉल्स अंडर विच ऑर्डर. So you must know the orders, right? Very much in good means आपको इनफैक्ट मैं तो कहती हूँ सेक्शंस तो होने ही चाहिए पता, और जो ऑर्डर नंबर्स है एटलीस्ट ऑर्डर नंबर्स के साथ ऑर्डर की हेडिंग भी पता होनी चाहिए सारे के सारे ऑर्डर्स की, और विद इन द ऑर्डर्स जो रूल्स फॉलो करते हैं वो कुछ कुछ रूल्स ही आपको याद रहने चाहिए, और जो ऑर्डर का मेन क्रक्स क्या है वो पता होना चाहिए आपको. जैसे कि हमने पढ़ा डिस्कवरी एंड इंस्पेक्शन, वो कहना क्या चाहता है? You should know the crux. Similar was with admission. Similar is with this: production, impounding, and return of documents. Never anything has been asked, but I will just tell you what it is trying to say. Production means produce करना कोर्ट के सामने, impound करना यानी confiscate करना, अपने पास रख लेना, and return कर देना, right? जो बोनाफाइड ओनर होता है डॉक्यूमेंट्स का, उसको वापस रिटर्न कर देने वो डॉक्यूमेंट्स. दैट इज व्हाट इज दिस ऑर्डर ट्राइंग टू से, राइट? Original documents to be produced at or before the settlement of issues, right? The parties or the pleaders shall produce on or before settlement of issues all documentary evidence in original where copies thereof have been filed along with the plaint or written statement, right? The court shall receive the documents so as produced, proviso that they are accompanied by an accurate list. वो तो आप सबको पता होता है, एक लिस्ट होता है इन द वे हाई कोर्ट डिसाइड्स, एंड नथिंग इन दिस रूल शैल अप्लाई टू डॉक्यूमेंट्स. ये आपको पता होना चाहिए कि विच आर यूज फॉर क्रॉस एग्जामिनेशन ऑफ द विटनेसेस ऑफ अदर पार्टी एंड विच आर हैंडेड ओवर टू द विटनेस merely for refreshing of his memory, right? Rejection of irrelevant or inadmissible documents you can reject जो रेलिवेंट है ही नहीं केस को लेके. इंडोर्समेंट ऑन डॉक्यूमेंट्स एडमिटेड इन एविडेंस. आपको इंडोर्समेंट का मतलब पता तो है आपको कि आपको सिग्नेचर करना है, डेट करना है, वो वाला इंडोर्समेंट होता है इस पे. इंडोर्समेंट ऑन कॉपीज ऑफ एडमिटेड एंट्रीज इन बुक्स, अकाउंट्स एंड रिकॉर्ड्स, यू हैव टू एंडोर्स दोस डॉक्यूमेंट्स ऑल्सो. ओके, फिर इसके बाद आता है go to rule number 8. Court may order any document to be impounded, right? Means basically kept in the custody of the officer of the court, because the court thinks fit that it is much necessary that we must keep it within the premises of the court. Return of the admitted documents, right? You can return them. That is what they are saying. Any person, whether a party to the suit or not, desirous of receiving back any document produced by him in the suit and placed on record shall, unless the document is impounded under rule number 8, be entitled to receive it back. The same whether where the suit is one in which an appeal is not allowed when the suit has been disposed of, obviously. Okay, where the suit is one in which appeal is allowed when the court is satisfied that the time for preferring the appeal has elapsed and that no appeal has been preferred, or if an appeal has been preferred when the appeal has been disposed of. Proviso that a document may be returned at any time earlier than that prescribed by this rule if the person applying thereof delivers to the proper officer for being substituted for the original certified copy लाना ordinary. Or proviso also that no document shall be returned which by force of the decree has become fully void or useless. ये याद रखना. अगर वो document को in deciding of the suit and after a judgment and a decree is being passed, a decree is drawn and it comes to the conclusion that ये document की अब कोई value ही नहीं है, means it has not been passed in the favor, so it has become void, useless, then obviously you will not be given that document back. On return of document, obviously a receipt एक तरीके का proof तो होना ही चाहिए. That's what they are saying. So remember that what this basically order number 13 talks about producing the documents which are necessary for the suit. Impounding of the documents means keeping in the court's custody, and then return of the documents, right? Just a second. Okay, so now just write down before order number 14 one sentence. Issues are the backbones to a suit. Backbone यानी कि important part of the suit. They are the lamppost which enlighten the parties to the proceedings. the trial court, and even the appellate court. Means they are very much necessary. अगर कोई issue ही नहीं है, तो why will the proceedings take place? That is what they are trying to say from this. So settlement of issues and determination of suit, firstly on issues of law or on issues which are agreed upon. Okay, so for everything is given in the heading only: settlement of issues and determination of a suit on firstly issues of law or on issues agreed upon. Rule number 1: framing of issues. Issues arise when material proposition of fact, okay, of law is affirmed by one party and is denied by the other, right? Obviously means एक पार्टी अग्री करती है, दूसरी पार्टी उसको डिसअग्री करती है, तो देन ओनली इश्यू विल अराइज. Material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. Very very simple. Okay, कि एक plaintiff बोलेगा कि yes, this issue has arose and I have a right to sue, and defendant says I have a right to constitute my defense, means I have a right to attack whatever the plaintiff is claiming. Each material proposition affirmed by one party and denied by the other shall form the subject of a distinct issue. Issues are of two kinds. Firstly, issue of fact and issue of law. At the first hearing, जहाँ पे लिखा है ना at the first hearing को highlight करके लिख दीजिए order number 15, क्योंकि order number 15 में उन्होंने बात करी है first hearing के बारे में. At the first hearing of the suit, the court shall, after reading the plaint and the written statement, if any, means obviously आपने जब हमने written statement से लेके जो हमने order पढ़ा, तो उसमें उन्होंने लिखा है may file a written statement. So it is not necessary कि always a written statement is filed as a reply to the plaint. That is why they are saying after reading the plaint and the written statement, if any, and after examination under rule 2 of order number 10, means oral examination of the parties, and after hearing the parties or the pleaders or their pleaders ascertain upon what material proposition of fact or of law the parties are at variance, means वो लोग differ करते हैं, and shall thereupon proceed to frame and record the issues on which a right decision of the case appears to depend. Nothing in this rule requires the court to frame and record issues where the defendant at the first hearing of the suit makes no defense. तो आप ये रूल से आपको बस इतना दिमाग लगाना है इसमें कि इसमें इन्होंने बात करी इश्यूज दो टाइप के होते हैं, इश्यू ऑफ फैक्ट, इश्यू ऑफ लॉ. और प्लेंटिफ और डिफेंडेंट दो पार्टीज होती है. प्लेंटिफ क्लेम करता है, डिफेंडेंट अपोज करता है. तो कोर्ट देखेगी आफ्टर हियरिंग द पार्टीज, फिर प्लेंट रिटन स्टेटमेंट है अगर, तो वो सबको रीड करके कोर्ट अपना इश्यूज फ्रेम करती है. ओके, और फिर उसके ऊपर प्रोसीड अपॉन करती है. दैट इज व्हाट दे आर सेइंग, फ्रेमिंग ऑफ इश्यूज अंडर रूल नंबर 1. Rule number 2: court to pronounce judgment on all issues, notwithstanding that a case may be disposed of on preliminary issue. Court shall, subject to the provisions of sub-rule 2, pronounce judgment on all issues. Whether issues both of law and of fact arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only, it may try that issue first if that issue relates to the jurisdiction of the court or a bar to the suit created by law. यानी कि इश्यू ऑफ लॉ इज बीन ट्रीटेड एज अ प्रिलिमिनरी इश्यू. यहाँ पे मीन्स इट हैज़ टू बी डिस्पोज्ड ऑफ फर्स्ट, एंड फॉर दैट पर्पज में इफ इट थिंक्स फिट postpone the settlement of the other issues until after that issue has been determined, and may deal with the suit in accordance with the decision of the issue. Materials from which issues may be framed, obviously whatever is said on oath, their pleadings, right, and the documents, interrogatories, ये सारी चीज़ों को into consideration कोर्ट करेगी और issues frame करेगी. Court may examine witnesses or documents also before framing of issues, obviously, right. Power to amend and strike out issue, the court has that power to amend and strike out issues. The court may at any time before passing decree amend the issues or frame additional issues on such terms as it thinks fit, and all such amendments or additional issues as may be necessary for determining the matters in controversy between the parties shall be made or framed. The court may at any time before passing a decree strike out any issues that appear to be wrongly framed or been introduced. Questions of fact or of law may by agreement be stated in form of issues. तो ये क्या बता रहे हैं इन एग्रीमेंट यानी कि बोथ द पार्टीज अग्री यहाँ पे कि हम कोर्ट का जो भी डिसीजन आएगा हम उसके ऊपर अमल करेंगे. ओके. Where the parties to the suits have agreed as to the question of fact or of law to be decided between them, they may state the same in form of an issue and enter into an agreement in writing that upon the finding of the court in the affirmative or negative of such issue, जो भी court का finding होगा, right, with respect to a sum of money specified in the agreement, with respect to the property which is specified in the agreement which is in dispute between the parties, and with respect to an act which one party is to do and which a party is not to do. So इसमें तीन चीजों को लेके है. The parties they agree in writing and they state it for the opinion of the court. One is with respect to money, one is with respect to property, and one is with respect to an act, right? And court, if satisfied that the agreement was executed in good faith, may pronounce a judgment. तो इन्होंने क्या करा, अग्री किया, कोर्ट को दिया, फिर कोर्ट satisfied है, it will conduct an inquiry, and after that whatever judgment the court wishes to give in favor or what in favor of the parties and वगैरह, the court will pass a judgment and shall upon finding or decision pronounce judgment on the terms of agreement, and on the judgment a decree shall follow. That is what they are saying. Okay. Now disposal of suit at first hearing. मैंने आपको बताया था कि ऑर्डर नंबर 15 टॉक्स अबाउट डिस्पोजल ऑफ द सूट एट फर्स्ट हियरिंग. पार्टी इज नॉट एट इश्यू, कोई है ही नहीं, राइट, कुछ इश्यू ही नहीं है. सो ऑब्वियसली द कोर्ट में एट वंस प्रोनाउंस जजमेंट. वन ऑफ सेवरल डिफेंडेंट्स नॉट एट इश्यू, राइट, बहुत सारे डिफेंडेंट्स हैं बट वन ऑफ देम इज नॉट एट इश्यू. तो जो जो इश्यू में नहीं है उसके अगेंस्ट तुम जजमेंट pronounce कर सकते हो. Parties are at issue. Now the parties are at issue. So what will happen? Logic लगाओ, right? तो the court will conduct an inquiry, right? कि argument necessary है, obviously so that no injustice is being done to the parties. Then the court will send summons, means the normal course which is being followed, it will follow, and then it will pass its judgment. Failure to produce evidence, summon भेजे थे and the party has not produced evidence. So see, when a summons has been issued for final disposal of suit and either party fails without sufficient cause to produce the evidence on which he is relying, the court may at once pronounce judgment or may, if it thinks fit, after framing and recording issues, adjourn the suit for production of such evidence as may be necessary for its decision upon such issues. Okay, this is it. आप खुद इसमें दिमाग लगाइए. हियरिंग क्यों होगी जब पार्टीज आ रहे हैं इश्यू. अगर पार्टी इश्यू में ही नहीं है तो ऑटोमेटिकली जो कोर्ट होता है वो क्या करता है, जजमेंट प्रोनाउंस कर देता है. दैट इज व्हाट दे आर सेइंग अंडर ऑर्डर नंबर 15. Okay, so that is it. Now summoning and attending of witnesses, इसमें आप ऐसे तरीके से लिख दीजिए. सबसे पहले issues are framed, उसके बाद एक एरो करिए, वहां पे 15 days लिखिए, फिर देन सबमिट द लिस्ट, फिर उसके बाद वापस एक एरो करिए, वहां पे 5 days लिखिए, और वहां पे लिख दीजिए obtain summons through application. List of witnesses and summons to witnesses on or before such date as the court may appoint, and not later than 15 days after the date on which issues are settled,
यानी कि framed यहाँ पे, okay? The parties shall present in court a list of witnesses whom they propose to call either to give evidence or to produce documents and obtain summonses to such person for their attendance in court. A party desirous of obtaining any summons for the attendance of any person shall file in court an application stating therein the purpose for which the witness is proposed to be summoned. The court, for reasons to be recorded, may permit a party to call, whether by summoning through court or otherwise, any witness other than those whose names appear in the list referred to in Subrule 1, if such party shows sufficient cause for the omission to mention the name of the witness in the list. Subject to the provisions of Subrule 2, summonses referred to in this rule may be obtained by the parties on an application to the court or to such officer as may be appointed by the court in this behalf within 5 days of presenting the list of witnesses under Subrule 1. तो मैंने आपको जो एरो के थ्रू बताया तो वो याद रखना, बस सिंपल है. इश्यूज फ्रेम, फिर एक हॉरिजॉन्टल एरो लिखे करिएगा, 15 days, फिर सबमिटिंग अ लिस्ट ऑफ ऑब्वियसली द विटनेसेस विच दे विश टू कॉल फॉर प्रोड्यूसिंग एविडेंस और गिविंग ऑफ सम डॉक्यूमेंट्स वगैरह, राइट. तो वो लिखिए, सबमिटिंग द लिस्ट, अगेन अ हॉरिजॉन्टल एरो, और वहाँ पे लिखिए 5 days, एंड यू देन विल ऑब्टेन द समन्स थ्रू दिस एप्लीकेशन फ्रॉम द कोर्ट, दैट इज समनिंग एंड अटेंडेंस ऑफ द विटनेसेस. अच्छा, जो हमने समन से रिलेटेड जो ऑर्डर पढ़ा था, इट इज समवॉट सिमिलर ओनली यहाँ पे. दैट इज, वो कौन से समन्स थे? वो समन्स थे सेंडिंग इट टू द डिफेंडेंट. यहाँ पे समन्स जो है हम भेज रहे हैं किसको? विटनेसेस को. Production of witnesses even without summons, right? Subject to provisions, if any party to the suit may, without applying for summons, may bring a witness to give evidence or to produce documents. So that is also the expense of the witness to be paid into court, obviously, for summons of not later than 7 days from making application. आपको उसके जो भी expenses होंगे, आने जाने वगैरह के जो भी खर्चे वगैरह होंगे, वो आपको भरना पड़ेंगे. एक्सपर्ट को अगर आप बुलाना चाहते हो टू गिव एविडेंस तो उसका भी खर्चा आपको देना पड़ेगा. स्केल ऑफ एक्सपेंसेस वो कौन डिसाइड करता है? हाई कोर्ट. वेदर द कोर्ट इज वेयर द कोर्ट इज सबऑर्डिनेट टू हाई कोर्ट रिगार्ड shall be had fixing the scale, right? Expense to be paid directly to the witness, that's what they're saying. Tender of expenses to witnesses, you have to give it when you're going to give the summons, right? So this is, but they're just saying that you will send summons to witness so that the witnesses come and they give their evidence, documents जमा करवा देते हैं वगैरह. देखो, now time, place, purpose वो सब mention किया जाएगा. Summon to produce documents, right? तो अगर summons to produce documents है तो you can dispense of the attendance, right? It's not necessary that the witness has to come. They can just वो आके जमा करवा सकते documents. Power to require persons present in court to give evidence or produce. Any person who is present in the court has the power, right? Court's discretion है ये वाला एक. अगर आए, ये तो जनरल क्वेश्चन है, which all instances talk about the discretionary power of the court. This is one of the discretionary power. Summons given to the party for service, right? You can even send डस्टी सर्विस, जो हम कहते हैं डस्टी समन्स कहते हैं, ये वो वाला है. पार्टी को ही बोलेंगे आप जाके दे आइए समन्स. हाउ इट इज सर्व, जैसे डिफेंडेंट को सर्व किए जाते हैं उसी तरीके से इसमें भी समन किए जाएंगे. सो राइट, रूल नंबर 10 याद रखेगा. Procedure where the witness fails to comply with the summon, right? So this is uh, a kind of a penalty. It's penal it is penal in nature. Is if you do not comply with the summons, right? Fails to comply with the summon. So basically what this rule is trying to say, that the summons must be strictly followed, right? So what happens is, where a person to whom a summon has been issued to attend to give document or evidence fails to attend, right? Basically he doesn't comply. So the court shall, if the certificate of the serving officer has not been verified by affidavit, or if the service of the summon has been effected by the party or his agent, or may, if the certificate of the serving officer has been verified, examine on oath the serving officer or the party or his agent, as the case may be, who has given the service, or cause him to be examined by the court touching the service or non-service of summon, right? Court sees reason to believe that such evidence of production of document or material is very much necessary, right, and that person has failed to give the evidence, right, तो वहां पे प्रोक्लेमेशन इफ अफिक्स करवा के आएंगे आउटर डोर पे, अटैचमेंट तरीके का होगा, राइट, उसकी प्रॉपर्टी भी जब्त कर सकते हो, दैट इज व्हाट दे आर सेइंग, ओके, यू डोंट नीड टू डू एनी ऑफ दिस अदर थिंग्स। देखो हमने वो समन्स टू डिफेंडेंट वाले में भी पढ़ा था, they have to stay within the territorial jurisdiction of the court. Similar rule number 19 also talks about that. No witness to be ordered to attend in person unless resident within certain limits. तो इसमें इन्होंने limits दी है, वो आप एक बार देख लीजिएगा, right? You don't need to go in all that. 15A talks about attendance of witnesses जो कि prison में वगैरह है, right? कभी कभी उनकी भी ज़रूरत होती है, राइट, फॉर द डिस्पोजल ऑफ द सूट, तो ये वो बात कर रहा है। फिर एडजॉर्नमेंट मोस्ट इम्पॉर्टेंट, सॉरी 16A था, अटेंडेंस ऑफ विटनेसेस हु आर कन्फाइंड और डिटेन्ड इन प्रिजन, तो अगर वो ज़रूरी भी है, ही कैन बी बॉट इन कस्टडी, राइट, टू द कोर्ट, ये वो बता रहे हैं, सो दैट वो भाग ना जाए वहाँ पे से। कमीशन भी इश्यू कर सकते हैं अगर ज़रूरत है भेजने के लिए, और कमीशन अगर इश्यू करते हो तो ऑर्डर नंबर 26 के जो सारे प्रोविजंस है वो एप्लीकेबल होंगे। एडजॉर्नमेंट ऑर्डर नंबर 17, मोस्ट वन ऑफ द मोस्ट इम्पॉर्टेंट ऑर्डर्स, प्रीलिम मेंस इंटरव्यू सब चीज़ के लिए। कोर्ट में ग्रांट टाइम एंड एडजॉर्न द हियरिंग, द कोर्ट में, see when I stress on the word may and shall, please pay attention, okay, means now it should automatically strike to you, agar may hai means it is not mandatory, means it's the discretion of the court. The court may, if sufficient cause is shown at any stage of the suit, grant time to the parties or to any of them, and may from time to time adjourn the hearing of the suit for reasons to be recorded in writing, provided that no such adjournment shall be granted more than 3 times to a party during the hearing of the suit, यानी कि हर एक पार्टी को तीन 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 का मिनिमम मिलेगा। What are the costs of adjournment? In every such case, the court shall fix a day for further hearing of the suit and shall make such orders as to the cost which are occasioned by the adjournment or such higher costs as the court deems fit. Provided that when the hearing of the suit has been commenced, it shall be continued from day to day until all witnesses in attendance have been examined, unless the court finds that for exceptional reasons to be recorded in writing, the adjournment of the hearing shall be done. No adjournment shall be granted at the request of the party except where the circumstances are beyond the control of the party. The fact that the pleader, now see these things, ये सब है ना, इन्होंने बोला adjournment तो हम दे सकते हैं लेकिन फालतू का adjournment नहीं दे सकते, that is what they are saying, okay. So इसमें इन्होंने ये बोला है कि the fact that the pleader of the party is engaged in another court shall not be ground for adjournment, whether where the illness of the pleader or his inability to conduct the case for any reason other than being engaged in another court is put forward as a ground for adjournment, the court shall not grant the adjournment unless it is satisfied that the party applying for the adjournment could not have engaged another pleader in time. Where the witness is present in court, but the party or his pleader is not present, or the party or his pleader, though present in court, is not ready to examine or cross examine the witness, the court may, if it thinks fit, record the statement of the witness and pass such orders as it thinks fit, dispensing with the examination in chief or cross examination of the witness, as the case may be, by the party or his pleader not present or not ready as aforesaid. अगर witness देखो तो ई के बगल में witness को लेके लिख दीजिए, डी के बगल में प्लीडर को लेके ही लिख लीजिए, और सी के बगल में भी प्लीडर, राइट, और ए एंड बी आर सम काइंड ऑफ नॉर्मल प्रोविजंस, राइट। अगर प्लीडर कहीं और कोर्ट में दूसरे केस में इन्वॉल्व है तो दैट इज नॉट अ वैलिड रीजन फॉर obtaining adjournment, बट हाँ डेफिनेटली इफ ही इज इल, वेरी इल, इनेबल टू कम, राइट, तो आप वो रीजन से आप एडजॉर्नमेंट ले सकते हो। विटनेस प्रेजेंट है, पार्टी प्लीडर नहीं है, वो क्रॉस एग्जामिनेशन नहीं करना चाहती, कोर्ट कैन गो अहेड। Procedure: if party fails to appear on the day fixed, where on any day to which the hearing of the suit is adjourned, the parties or any of them fail to appear, the court may proceed to dispose of the suit in one of the modes directed in that behalf under order number 9, or make such order as it thinks fit, यानी कि disposal of the suit order number 9 के तहत उसको किया जाएगा. Explanation where the evidence or a substantial portion of the evidence of any party has already been recorded and such party fails to appear on any day to which the hearing of the party is adjourned, the court may in its discretion proceed with the case as if the party was present. Right? Court may proceed notwithstanding either party fails to produce evidence. Court to proceed karegi. That's what they're saying. Where any party to the suit to whom time has been granted fails to produce evidence or brings witnesses, right, or to perform any other act which is necessary for the progress of the suit for which time has been allowed, the court may, notwithstanding such default, right, if the parties are present, proceed to decide the suit. If the parties are or any of them is absent, proceed under rule number 2. So देखो, अगर प्रीलिम पर्सपेक्टिव की अगर हम बात करें तो एडजॉर्नमेंट फॉल्स अंडर विच ऑर्डर, adjournment, how many times adjournment can be given, right? That is sufficient for prelim perspective, right? We know that every party gets it for 3 times, right? ये वो बता रहे. But mains perspective, a long answer definitely comes, right? Directly a lengthy answer in brief type आता है पूरा का पूरा, okay? Means 6 marker or something like that, राइट. सो ये आपको प्रीलिम पर्सपेक्टिव तो बहुत सिंपल है, डायरेक्ट क्वेश्चन ही आ जाएगा. यू डोंट नीड टू ब्रेक योर हेड कि क्या आएगा क्या नहीं आएगा इसमें. ऑर्डर नंबर 18 इज टॉकिंग अबाउट हियरिंग ऑफ द सूट एंड एग्जामिनेशन ऑफ विटनेसेस. बस इसमें आप ऊपर से जान दीजिए ये ऑर्डर जो हमने विटनेसेस आए थे ये उनका एग्जामिनेशन हो रहा है. नो नीड टू गो इनटू द डेप्थ ऑफ दिस. इसमें उनको हियर करेंगे, उनके रिकॉर्ड करेंगे एविडेंस वगैरह, ये वो है. एक बार ऊपर ऊपर से ये देख लीजिएगा ये इसमें क्या है. मीन्स जस्ट सी द हेडिंग्स ऑफ ऑल द रूल्स, राइट. यू डोंट नीड टू, कभी इससे पूछा भी नहीं है कुछ भी, एंड यू डोंट नीड टू इवन ब्रेक योर हेड ऑन दिस पर्टिकुलर ऑर्डर, राइट. अभी ऑर्डर नंबर 19 जो बात करता है एफिडेविट्स की. फर्स्टली तो यू शुड नो अंडर विच ऑर्डर इट इज, राइट. दैट एफिडेविट फॉल्स अंडर ऑर्डर नंबर 19. इफ़ यू गो टू सी एफिडेविट का डेफिनेशन सीपीसी में तो नहीं दिया है, दैट्स व्हाट दे आर सेइंग. इंडियन एविडेंस एक्ट एप्लीकेबल होती है, ये भी है इसमें, राइट. पावर टू ऑर्डर एनी पॉइंट टू बी प्रूव बाय एफिडेविट. कोर्ट के पास फुल पावर है कि कोई पर्टिकुलर पॉइंट है आपको वो एफिडेविट के ज़रिए ही प्रूव करना पड़ेगा, राइट. So that is what they are saying. Power to order any point to be proved by affidavit. Power to attendance of the deponent for cross examination, right? जो जिसने एविडेंस दिया है एफिडेविट के जरिए, so that deponent has to appear for cross examination. Court has the power. If the court exercises that power, right, that particular person has to appear for cross examination purpose. मैटर्स टू विच द एफिडेविट शैल बी कन्फाइंड. कौन से मैटर्स को लेके कन्फाइंड होगी, कौन से मैटर्स तक ही वो एप्लीकेबल होगी, राइट. एफिडेविट शैल बी कन्फाइंड टू सच फैक्ट्स एज द डिपोनेंट इज एबल of his own knowledge to prove, right. Means he should be, अगर उसने कुछ एफिडेविट में मेंशन किया है डिपोनेंट ने, he should be able to answer that. That is what they're saying. And obviously in affidavit वो facts को लेके ही बात कर रहे हैं, right. Essentials of the affidavit is with respect to fact, it is in writing, it is always in first person, it is sworn or affirmed. किसके सामने हम affidavit sworn कर सकते हैं, उसके सामने affirm sworn करा हुआ होना चाहिए. So this is it. We'll stop over here only. Order 20